Judge Shapiro, it looks like we have the court reporter as well as attorneys for both sides. I can bring them in whenever you're ready.
Okay. We can begin whenever we get everybody on the picture here.
I will bring them in.
Thank you.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor. Good seeing you. I haven't seen you in a long time. I had hair, I think, the last time I saw you.
I'm sorry?
I said I had hair the last time I saw you. It's been a while.
All right, so I'm just going to call the case. It's Brown versus Michigan, docket number 21-190 in the Court of Claims. We have counsel for both parties here. And Mr. Fish, this is your motion, right?
Yes, thank you, Your Honor. Your Honor, Gallant Fish on behalf of defendant the state. And in each of these cases, Your Honor, our goal is to apply this statute as faithfully as possible. And in this case, we brought our motion for summary disposition because we don't believe that the statute affords plaintiff relief. And that is because new evidence did not result in the dismissal of the plaintiff's charges. And the WICA statute and MCL 691.17551C requires 3 showings based on new evidence. The new evidence demonstrates innocence, that it resulted in the reversal or grant of a pardon, and that it resulted in the dismissal of all charges or finding of not guilty on retrial. And then, as Your Honor is aware, in Tomasic, the Court of Appeals confirmed that these are 3 separate requirements under the statute. And then last year in Maples, the Supreme Court reiterated that these are the 3 requirements for relief, basically under the statute. And then in Sullivan, the Court of Appeals explained that even if new evidence resulted in the reversal of the convictions, if it did not also independently result in the dismissal of the charges, that the statute does not grant relief. And so,
a preliminary question, Mr. Fish.
Of course.
So first of all, I assume, at least for purposes of this motion, you're not contesting the first 2 prongs.
Not for purposes of this motion, Your Honor, but we're also not conceding the other 2 prongs.
All right. But today we're dealing just with the 3rd prong.
Correct.
Okay. Now, is this a question of law to be determined by the court or one of fact? Does the statute indicate?
Your Honor, our understanding is that it is a question of fact to be determined. It's essentially a historical inquiry of what was the reason for the dismissal when it occurred. In this case, our position is that there's not a question of material fact for purposes of summary disposition, but that this is under the statute a factual inquiry.
Okay. You can continue if you have more you want to cover. I just wanted to ask that question.
Thank you, Your Honor. Essentially, our argument is that when we look at the record in this case, the record is clear that the dismissal is unrelated to the new evidence. The record in this case is the nolle pros order, which the prosecutor and the court signed, which indicated that the reason for the dismissal was the family did not wish to proceed. And in this case, even if we...
Prosecutor, I'm sorry, I'm used to Court of Appeals.
Of course.
I'm sorry, now I lost my train of thought just a second.
You said something about the prosecutor, Your Honor.
Oh, yes, thank you. What if a prosecutor signed an affidavit and said, we're just too busy in our office to retry this? Is that the end of the case?
Your Honor, I think to the extent possible, we should be limiting our inquiry to the actual record of the criminal case, rather than looking at kind of statements made by the prosecutor in the context of the WICA proceedings.
Don't
And
we
some,
have that here?
I'm
Don't
sorry,
we
Your
have an
Honor.
affidavit? Don't we have an affidavit from the prosecutor prepared for the WICA proceeding? Isn't that what you're relying on, or am I missing it?
No, we're relying on the noli pros order itself, in addition to the deposition that was taken of the victim's mother, Lenora Horton.
Why is the prosecutor bound by the wishes of the victim's mother? Don't they make an independent determination whether to pursue retrial?
I don't think that the prosecutor is bound. And I think for the purposes of the WICA inquiry, we're basically looking at what was the prosecutor's reasoning, what was their motivation. In this case, they indicated that their motivation was not wishing to put the victim's family through a retrial. And then when we deposed Ms. Horton, she confirmed that she did have that conversation with the prosecutor and told the prosecutor that she did not feel emotionally capable of a retrial.
Understand. Okay. Anything
And-
else at the moment?
Nothing further, Your Honor. I think that's the basis of the
rebuttal.
argument, and it's clear in the motion or in the brief as well.
Okay, thank you.
Thank you.
Mr. Mueller, go ahead.
Thank you, Your Honor. I'm going to make this hopefully pretty brief. I want to talk first a little bit about the facts and the evidence in this case and what you had talked about. Then I just want to briefly distinguish the Sullivan case and the Ferranda Smith case that was relied upon by Mr. Fish. First of all, in this case, what we have is new evidence brought by the University of Michigan Innocence Clinic, the medical and science evidence, which resulted in the new trial. Then we have the mom saying, one on page, that's exhibit 6, page 9, I spoke to the U of M folks. They explained this alternate reason of that the death could have been caused. And then I spoke to the prosecutor and I couldn't go through with it. It is
Hang on one moment. Hang on, I'm looking at this. It says on page 6.
page 9 on exhibit 6, Lenora Horton's testimony.
Yeah, I got it just a second. Oh, yes. Okay, I see it. Thank you.
She
Go ahead.
spoke to the U of M folks. They explained it. And then she spoke to the prosecutor. She couldn't emotionally go through with it. So what we have is, and it's not, the statute doesn't require some direct connection. It's new evidence resulted in a new trial. Because of the new evidence, the case was dismissed. And for whatever reasons, as the court said, and I mentioned this in my brief, Your Honor, the prosecution could game the system every single time. We're dismissing in the interest of justice. We're dismissing because we are just too busy. It doesn't.
Well, I understand that problem.
Okay.
But the question is whether or not they're gaming the system in this case, right?
Well, in this case, they just simply didn't say because of the new evidence, but it's connecting A to B and B to C. A leads directly to C. Because
Have you deposed the prosecutor?
the prosecutor, no, I spoke to the prosecutor, frankly, that they didn't want to frankly participate in this case. And we're going to say we're just relying on what the document says.
Well, what have you got then? If you don't have anything, if you don't have any impeachment of the prosecutor's affidavit, why is there a question of fact?
I think because we're talking about a C-10 motion, that all inferences are construed in the favor of the non-moving party, the plaintiff. We have with Lenora Horton's testimony at minimum question of fact, but even still, we have beyond that, frankly, we have A leads to B, which is the medical evidence leads to the vacation of the conviction and a new trial. B leads to C, there is a new trial. She doesn't want to proceed because of the new evidence. That's the reason we're here. So those are the facts of this case. And just as to distinguish Sullivan and Ferranda Smith, in Sullivan, it's frankly dicta what Mr. Fish is relying on because it wasn't necessary to the ruling. In the Sullivan case, the claimed new evidence was the polygraph and a recantation. And if you remember Sullivan
Case, the 3 different versions of the recantation.
right, it's all the same recantation. So it didn't meet the other part of the statute requires other supporting evidence to support. So the case got dismissed on that ground. And then it said, even if that's the case, but it wasn't necessary for the decision. That decision was based on the recantation not meeting the requirements of the statute. But to distinguish that, We also had a subsequent ruling, as you remember, by the trial court where the prosecution said, well, we want to introduce the original trial transcript of this witness in our case in chief. And the judge said no. So that was the reason for the dismissal. So that's distinct from this case. And in the Ferranda Smith case, frankly, that's an easy one. That case was dismissed and a new trial was ordered based on a Brady violation by the prosecution. Then there was a second trial, which resulted in a mistrial. Then there was a third trial. And then as the plaintiff conceded, our new evidence that we're talking about is the new DNA evidence that wasn't even a part of the Brady decision. So that's black and white. The new evidence that caused the new trial wasn't the new evidence that caused the dismissal. It's not the same evidence. So those cases are distinct from what we have here, Your Honor. I think Your Honor gets it. I'll rely on the arguments I made here and in my brief, but Ferranda Smith is clearly distinct, and so is Sullivan from the facts of this case.
Hang on, I'm looking at the Maple case, which seems to be the most recent.
That had to do with the recantation.
Right. I'm just quoting something from it. Justice McCormick, I think, wrote it, but I'm not sure. In any event, it says here, a plaintiff's entitlement to compensation thus turns on whether they can prove that the new evidence caused a different result after their original conviction was set aside. And I mean, is it your position that at this point you have enough to prove that, or is it your position that you believe you could prove it at trial?
I think we could prove it at trial, and we are at a summary disposition stage, so all the reasonable inferences at this point go in favor of the plaintiff. And so with Lenora Horton,
where I'm concerned is that I have an affidavit from the prosecutor that says this is why we dismissed it. Tell me what inferences I'm supposed to draw from what that would constitute a question of fact as to his truthfulness.
We have the inference because Lenora Horton said, I spoke to the U of M folks. They explained the alternate reason, which is the medical science, and I couldn't go through with the new trial. So
right, you have a different view of that testimony, obviously, than the prosecutor.
Right.
And I understand.
Right. And then we have, as I said, the prosecution could make any kind of reason that wouldn't directly relate to the new evidence and put that in an order, a vanilla in the interest of justice. And that doesn't negate the statute and the WICA. Remember, this is a remedial statute intended to compensate the wrongfully convicted.
You handled several of these cases. Now I know I've seen a few. Have any gone to trial?
None of mine have gone to trial. They paid on pretty much everything that I've gone. I know Mr. Fish won a trial once.
Okay, they've either been settled, paid, or gone to, or been dismissed.
Correct.
Okay. Anything else, Mr. Mueller, before I go?
No,
back
Your
to
Honor. Thanks.
Thank you, Mr. Fish. Go ahead.
Just two quick points, Your Honor. Thank you. One, just going back to the deposition of Miss Horton on page 11 of that transcript at the bottom.
11?
Page 11, correct.
Mm-hmm.
The Miss Horton indicated that at the time that she talked to the prosecutor, she was not even aware of the new evidence yet at that point. And so our position is that this new evidence also did not play a role in Miss Horton's desire not to proceed. And just briefly, the second point, Your Honor, on the possibility of a prosecutor gaming the system, it is possible that if in this case there was a vanilla reason, like in the interest of justice, and there was a question as to was the prosecutor essentially trying to avoid a reference to the new evidence by providing a vanilla reason, it's possible in that case that there could be a question of fact that would need to be resolved at trial. But in this case, where there is a specific reason given, and that reason is unrelated to the new evidence, our position is that the statute is clear that it does not afford relief.
Mr. Mueller, you want to say anything about page 11?
Yes, I do, Your Honor. Just if you read 9, 10, and 11 in context, it says that at the time of the evidentiary hearing, page 9, this would have been the 2018 timeframe that she spoke to the U of M folks. And then later on, she said she was advised there was going to be a new trial. And then she says on page 11, this is line 9, that was so many years ago, I don't really remember details, but
Wait.
it's true.
And where are you here at this time?
Page 10 on exhibit 6, line 9, when she was talking about at some point in time, the prosecutor advised you why there's going to be a new trial. She says that was so many years ago, I don't remember details. How would you feel about a new trial? This is clearly after the evidentiary hearing, because there's no reason to have a trial unless you had the evidentiary hearing. And so to the extent that she's a bit ambiguous about it, it's still all reasonable inferences. There's a new trial, there's an evidentiary hearing, that's why we're here. And then the way that went is the prosecutor, how would you feel about a new trial? Well, I can't emotionally go through a new trial. So it's still based on the medical evidence. That's the only reason they're in Calhoun County to begin with. Thank you, Your Honor.
Mr. Fish, did you try one of these?
In the time that I've been with the office handling these cases, Your Honor, we've tried one. I tried that case, and as far as I'm aware, that is the only trial that has taken place on a WICA case.
Which judge did you try it in front of?
That was in front of Judge Murray.
And do you recall the name by chance?
It was Shamar Avery versus the state.
Okay. And what happened? What was the result, and has it gone up?
I'm sorry, Your Honor.
What was the result of the trial, and has the losing party appealed?
The Judge Murray decided in our favor, Your Honor, after a 2-day trial on the question of innocence in that case, and that is currently pending appeal.
But as the court has noted, Your Honor, I've probably handled 25 of these and been paid on every one. There was a summary judgment on one. We got a couple settled. And the summary judgment had to do with, I think, actual innocence, certainly not this issue.
Okay. Anything else from either of you?
No, Your Honor. Thank you. Appreciate it.
Nothing, Your Honor. Thanks.
I'm going to rule at this moment, but we will get an opinion and order out before too long. I typically do so within 30 days. If we can do it shorter, we will. If it takes a little longer, you'll have to excuse me.
Thank you, Your Honor.
Okay.
Have a good
Thank you, Your
weekend.
Honor.
All right,
Okay,
the hearing is concluded.
thank you. And counsel, do we need transcript?
I don't
Mr.
think so. If
Fisher,
we do later, we'll order one.
Okay, perfect. You have the same, Mr. Fish?
Yes, for the state as well, please. Thank you.
You do, or you will order it if you need it.
Correct. Yes, thank you.
All right. Thank you very much.
Thank you, Your Honor.
Bye.